Good afternoon and welcome to our webinar in relation to managing regulatory investigations. By way of quick introduction, my name is Tim Coolican. I'm a partner and head of the regulatory team at Anthony Collins, working within the corporate litigation team. My colleague who will be presenting the webinar with me is Matt Marsh, a solicitor from the governance and commercial team specialising in work for local government. This is a two-part webinar. The first today on the 18th rather than the 20th of October as shown on the slide, and part two on the 9th of November.
Hi, good afternoon everybody. Thank you, Tim. So as Tim said, this is part one of a new programme that we've devised with a mind to taking a bit of a step back from the specifics of investigations and prosecutions, certainly within part one, to look at the legislative basis on which your powers as local authority regulators arise from. So I'm going to have a look through the Legislative and Regulatory Reform Act with you, and then the all-important authorities that you need to have in place to undertake your regulatory and enforcement actions. Tim then will have a quick look at the Police Criminal Evidence Act and the Criminal Procedure and Investigations Act before passing back to me for a look at the all-important tests in the Code for Crown Prosecutors. And then part two of the programme, which Tim has said is on the 9th of November, we'll look in more detail specifically at Health and Safety at Work Act enforcement, taking into consideration the offences of corporate manslaughter and corporate homicide and the instructions of experts. I've got quite a lot to cover this afternoon, albeit from a fairly high level. Some of the slides are particularly detailed. I've got quite a lot of content on them, but you will receive a copy of the slides that you can peruse at your leisure and use as a resource after today's webinar. So to start off then, the Legislative and Regulatory Reform Act 2006. This Act came or was brought about following increasing concerns from businesses at the inconsistencies they were facing from various regulators, so particularly those that had operations in more than one local authority area. They were concerned that was the difference in compliance and regulatory regimes that they were facing depending on which local authority area they were in. So this piece of legislation sought to reduce what was considered to be overly burdensome regulatory and legislative compliance requirements, and to try and ensure that the actions taken by various regulatory bodies were more consistent. And it brought in 5 principles that all regulators were required to consider in carrying out their regulatory and enforcement functions. Those being that the actions should be transparent, they should be accountable, they should be proportionate, consistent and targeted. And that's to say they should be risk-based. Section 22 of the Legislative and Regulatory Reform Act provides for the Secretary of State to issue codes of practice to regulators as regards the undertaking of their regulatory functions. And that is from where we get the Regulators Code 2014. Which that came into effect in April of 2014 and replaced the previous Regulators Compliance Code, which itself replaced the Enforcement Concord Act. The code applies to all non-economic regulators, including particularly local authorities and fire and rescue authorities, who must have regard to that code when undertaking their regulatory functions. The code builds on those principles of transparency, accountability and such like, taken over from the Regulatory Reform Act 2006, and requires regulators to carry out their regulatory activities in a way that supports the business that they regulate to grow and comply, to provide simple and straightforward means with which to engage the businesses, to engage the regulators. Again, emphasises that regulatory activity should be based on risk, and that regulators should share information about their compliance regimes and the risks that they're seeking to address. Requires regulators to ensure that the information, guidance and advice is available to the businesses that they regulate, and to ensure, again, going back to the principle of transparency, that the regulators are transparent in their regulatory activities. That code also requires regulators to publish what the code refers to as service standards, and you can, which again emphasises the need to for regulators to communicate with the businesses that they regulate, to provide information and guidance, to set out how the regulators undertake their checks on compliance, provision of inspection plans, audits, monitoring, test purchases, and such like. Sets out any fees and charges that the regulators are going to impose on the businesses that they regulate. Provide a means for the business to complain about the actions or decisions of their regulators, and all importantly, requires an enforcement policy that sets out how the regulators will deal with non-compliance. So that is the basis upon which that you will have your enforcement and prosecution policy. There is no statutory form for the format of a local authority enforcement policy, and in formats and approaches to the policies do vary between local authorities. They should, however, address and demonstrate how that local authority complies with the regulatory principles set out in the 2006 Act, and indeed as set out in the Regulators Code. A number of local authorities kind of like adopt a corporate level policy, and then will have specific service area policies appended to that. The advantage being that the service area policies allow for any of the specific requirements or provisions of the legislation with which they're concerned to be taken into account. Of course, what is required for the regulation and licensing of HMOs isn't going to be the same as is required for hackney carriages and private hire vehicles. So it enables those service area policies to address, as I say, the specific requirements or provisions of that legislation. That said, it's important, of course, that there aren't any contradictions between a service area policy and your corporate level policy. The advantage of an enforcement policy as well is that it will also enable the provision of what's known as a stepped approach to enforcement, which again will feed into compliance with the Regulators Code and the requirements of the 2006 Act. So that will range from everything from no further action being taken to the issue of further advice and guidance, informal warnings, voluntary undertakings that you may require of a business that is struggling to comply with its obligations, moving up to the issue of statutory notices or the issue of administrative penalties, enforcement orders, injunctive actions, and then up to kind of the nuclear option, so to speak, a prosecution. Excuse me. The business is subject to licenses, then your enforcement policy should also address how non-compliance may result in the refusal, suspension, or the revocation of a particular license. Enforcement policy is also an opportunity to set out how, from a high-level view, the authority as a regulatory enforcement body will undertake their investigations. So you find that enforcement policies refer to the regulators completing their investigations in accordance with PACE and the Criminal Procedure Investigations Act, would have set out the process upon which prosecution decisions are made. So it's important to know what is provided for in your enforcement policy. You need to ensure that whatever course of action it is that you're considering or proposing to take, that it is aligned with the processes in your policy, and that if you're going to go outside of your policy, you can justify with reasons as to why you're going to do so. Primary authority, the Regulatory Enforcement and Sanctions Act 2008, very much legislation in the same vein as the Legislative and Regulatory Reform Act 2006. So again, it was with a view to trying to improve the consistency with enforcement actions taken by different local authority regulators. The primary authority scheme is a statutory scheme that arises from the 2008 Act, and it applies to regulatory functions carried out by local authorities, particularly as concerns licensing, trading standards, environmental health, and fire and safety. The scheme provides for a local authority as an enforcer, a regulatory enforcement body, to partner either with a business or with a group of businesses and to become their primary authority for the purpose of regulation and enforcement. The partnerships require the Secretary of State approval. There's a standard application process which goes up, and assuming that the Secretary of State approves the intended relationship, then that partnership will be registered on the Primary Authority Register. And the Primary Authority Scheme enables the local authority that is the primary authority for that business to provide the business with regulatory advice and guidance. And in certain circumstances also enables that primary authority to provide guidance to other regulatory local authorities. The scheme imposes a number of statutory duties on regulatory or on local authorities carrying out their regulatory function, where the business that they're dealing with has a primary authority partnership. Primarily, the regulatory authority will need to follow any inspection plan that has been issued to the business by the primary authority. And if the regulatory authority is considering or intending to take enforcement action against a partnered business, then it must notify the primary authority for that business. In urgent cases, such notification can be retrospective, but otherwise they need to liaise with and put the primary authority on notice that they're considering taking enforcement action against a particular business. Importantly, if that primary authority considers that the actions intended by the regulatory authority are inconsistent with any of the primary advice that it has issued to the business, then that authority can direct the regulatory authority not to take the intended course of action. And if the regulatory authority doesn't agree with the decision of the primary authority, it will need then to refer the matter to the Secretary of State and will be unable to proceed until the Secretary of State has made a determination. So, check before you're undertaking enforcement or regulatory or enforcement action. Firstly, that action is in line with your enforcement policy, and secondly, check the primary authority register. If the business you are looking to investigate or take action against is in a primary authority relationship, you must notify and liaise with the local authority that is acting as that business's regulatory authority. And you then need to ensure that you are following the primary authority statutory guidance and have a mind to the guide for enforcement officers looking to take enforcement action against a business that has a primary authority partnership relationship. Okay, so you've checked your enforcement policy and your proposed course of action is aligned with your enforcement policy, and you've checked to see whether or not the business you're looking to take action against is a primary authority partner. You then need to think about ensuring that you are authorised to undertake the action that you are considering. I suspect that most of you will be familiar with the concept that a local authority is a creation of statute, primarily now the Local Government Act 1972. But what that basically means, or a creation of statute basically means, is that any action or decision that is proposed, that is or is proposed to be taken by a local authority must have a statutory basis. Without it, the action or the decision taken may well be deemed unlawful. The general power for local authorities to appear in legal proceedings, that's either to prosecute or to defend, comes under section 222 of the Local Government Act 1972, and section 101 of the Local Government Act 1972 provides for local authorities to put in place arrangements for the discharge of its functions via committees, subcommittees, officers, or through an arrangement with another local authority. Local authority officers themselves must similarly be authorised by their authority to take whatever action it is that they need to take to fulfil their role. The authorisations themselves, or the means of such authorisations, will vary somewhat depending on whether the local your system of governance is that of a committee system or a leader and cabinet system. And it's the section 101 power that provides for that delegation of authority. And so initially you'll have at the higher level, you'll have your constitution, and then below that you'll have a scheme of officer delegation and quite likely a scheme of officer sub-delegation. Those are the arrangements for discharging your functions, and those are the arrangements that you're empowered to make under section 101 of the 1972 Act. It's important that those authorisations are set down clearly in your governance documents, because there may be a need to prove, if challenged, that the officers have the delegated authority to undertake the action which they're taking. Similarly, there are certain instances, particularly within health and safety or environmental situations, where officers will need to show that they are accredited or qualified to be undertaking the course of action that they're taking, in addition to the authorisation from their local authority. So the officers need to check, or you know, it needs to be clear that the boots on the ground, so to speak, officers are clearly and correctly authorised to do what they're doing. So you need to know your constitution and your scheme of officer delegation. That can be a little tricky sometimes to keep up with. Lots of structural reform going on in the world of local government, and local authorities themselves often changing their structures at the departmental level. So it's important to ensure that whatever restructuring is going on, that those delegations carry across to whatever the new department may be, and is similarly cascaded down you know, from the assistant directors or the heads of service down to the officers that are actually going to be undertaking the enforcement action. So having a little look now at the kinds of things that we think, again, from a high level, that you need to be thinking about once you're conducting your investigations, having ensured, as I said previously, that your actions are aligned with your enforcement policy, you've taken into consideration any primary authority requirements, and you're satisfied that your scheme of delegation empowers you to do what you're doing. From the actual investigation perspective, there are various things that you need to be thinking about, albeit they may be a bit sort of, common sense really, but important to bear them in mind nonetheless. So firstly, who is it you're investigating? Are you investigating an individual, or are you investigating an incorporated body, i.e. a company, or are you investigating an unincorporated association? It's important to know that, because the actions that you take are going to depend to some extent on the nature of whether it's an individual or a business that you're investigating. And certainly so far, if the matter got as far as a prosecution, then that is going to be a key consideration as well. What is it that you're investigating? You know, what is the complaint? For example, what is it about? You need to know your legislation, whether you're an environmental protection officer or a housing officer with an investigative and regulatory remit. You need to understand the offences that are provided for in that legislation and the various elements of the offence that you're going to need to prove to make out that an offence has been committed. Whilst you're thinking about that, you also have in mind to, is there any defence available to the suspect? Is there a statutory defence that is provided for within the legislation, or may they be able to avail themselves of a common law defence? And what does the legislation that you're dealing with empower you to do? Evidentially, again, you need to be thinking about what evidence is it that you need to make out the elements of the offence, and where are you going to get it from? You might be undertaking desk research initially, you might be checking your own registers, national registers, council tax records, land registry, company's house, NAFIN, DVLA, etc. Are you authorised to access those sources of information, and in the circumstances, is your access of those sources of information warranted and justified? Are you going to need to serve requisitions or notices for information? If yes, who are you going to serve them on? And again, you need to be thinking about whether it's an individual you're looking at in their capacity as a private individual, or whether you're looking at serving those notices on a company. Are you going to need witness statements? Are you going to need interviews? Bearing in mind, of course, that as a local authority, you don't have any powers to compel somebody to attend an interview. if they're not willing to attend an interview under caution in person, are you going to consider using written questions and written responses under caution? Are you going to need to search premises? Are you going to need to undertake any testing? Are you going to need to seize any material? We're thinking about your evidence again. How reliable is it? What's the source of that evidence? Is there any underlying motive, for example, if you've received complaints? And how reliable are your witnesses going to be? If the need arises for them to attend court, are they going to? Again, consider what defences your suspect may raise. Is there anything that they're likely to put forward by means of a defence? And if you think that a particular defence is likely, how are you going to rebut any defence or account put forward by the suspect, and what evidence are you going to need to rebut it? Are you going to require expert evidence? If you are, where are you going to get it from? Will you require authorisations under RIPA? And if so, are you satisfied that the requirements for a RIPA authorisation are made out? And it's important, of course, to remember that during the course of conducting your investigations, that you adhere to confidentiality and data protection requirements, and that you need to ensure your safety and the safety of anybody that's made a complaint that you're investigating and of your witnesses. Evidence handling, again, once you've obtained your evidence from whatever source it may be, you need to think how you're going to keep that evidence stored. Is it secure? Is the access to it restricted? Do you have in place logs to record the movement in and out of that secure storage? You need to think about the chain of custody to ensure that once that evidence is in your possession, that its movements are accounted for, and you need to think about how and who is going to exhibit that evidence. Evidence can't stand alone by itself. It will need to be exhibited by means of a witness statement, be that you as the investigating officer or as a witness. Time limits, particularly important for local authorities. Most regulatory offences are summary only, which means they're only triable in the magistrates' court, and they will be commenced by your prosecutor laying informations. Ordinarily, those informations must be laid within 6 months of the offence date, although some statutes do provide for an alternative time frame. So it's important that you liaise with your legal team if needs be to ensure that the investigation is going to be complete and you'll have the evidence in time to comply with any deadlines for laying of information. Either way offences, not usually a time limit for those, but again, specific legislation may specify one. Indictable offences, not something that local authorities usually encounter. Tribal only in the Crown Court, and they won't have time limits. If there isn't a time limit, then it's given that the prosecutions must commence as soon as possible. You need to be aware that unjustified substantial delays may result in your summons being dismissed due to that delay on the basis of an abuse of process. So you've got your investigations complete, you've got your evidence, and then you need to think about the course of action you're going to take. So again, is your proposed course of action in line with your enforcement policy? If necessary, consult with your legal team on that regard. And if the decision is erring towards a prosecution, then that prosecution must not be started until the Code for Crown Prosecutors has been considered and the full code test has been satisfied. and I'll have a look at that with you a little bit later on. But now I'm going to pass over to Tim, who's going to have a look at PACE and the Criminal Procedure and Investigations Act. Tim.
Thank you, Matt. I'm now going to spend a few moments looking at the requirements outlined in the Police and Criminal Evidence Act 1984, otherwise known as PACE, and the Criminal and Procedure and Investigations Act 1996, known as the CPIA. Both PACE and the CPIA set out fundamental rules designed to ensure that suspects and defendants are treated fairly. In both cases, they set out to respond to concerns raised in a number of cases regarded as miscarriages of justice. Their requirements can often be seen by investigators as getting in the way of securing justice, but when followed correctly, they can assist prosecutors in establishing well-found cases. PACE outlines many powers and obligations placed upon the police. However, it also contains key provisions to ensure that the rights of suspects are maintained in all criminal investigations and set out key principles in relation to the admissibility of evidence. Those provisions apply to both police and non-police investigations, and a failure to comply can result in rulings that evidence is not admissible, which may result in the collapse of a prosecution if there's insufficient evidence remaining to provide a realistic prospect of a conviction. In more extreme cases, breaches of the provisions can result in proceedings being stayed by the court as an abuse of process. For example, where the court concludes that the defendant can no longer have a fair trial, or there's been an element of bad faith on the part of the investigator or prosecutor. Code C of PACE sets out the key requirements in relation to the detention, treatment, and questioning of suspects. And in the scenarios you're likely to be involved with, the key provisions will relate to the conduct of interviews. The rights of suspects include being given a clear explanation of what offences they're suspected of committing, being informed of their right to take legal advice, specific arrangements in relation to those who need interpreters, and to ensure that children or vulnerable adults have support to understand the process. Where interviews are being conducted on a voluntary basis, the suspect must be informed that they are free to leave. Perhaps most importantly, the suspect must be given a clear explanation of the caution, which I'm sure we're all familiar with. You do not have to say anything, but it may harm your defence. You do not mention when questioned something that you later rely on in court. Anything you do say may be given in evidence. While we all think we know what it means, it's often hard to explain it in practice. And in my experience, it's best broken down into 3 parts with an explanation given to the suspect, followed up by questions to check that they truly understand. We've outlined on the next slide some of the key points for the conduct of interviews. The main point is to behave professionally and fairly, to ask questions clearly and allow the suspect time to answer. Even if unprofessional conduct in an interview does not result in evidence being ruled inadmissible, it may make a court or jury more sympathetic to the suspect. And when defending clients, I would always rather be defending as a result of an unfair and unprofessional investigator, as they're often easier to pick apart. The rights to be accompanied at an interview are limited to a lawyer and, where it is necessary, either an interpreter or an appropriate adult. In some cases, an appropriate adult could be a relative, but beyond this, local authorities are under no obligation to permit friends or relatives to sit in on an interview under caution. And a friend or relative should never be permitted to act as an interpreter. We've then considered the point in relation to cases where concerns are raised in relation to the health, capacity or fitness of the suspect, and our advice would never be to proceed without resolving the issue by obtaining a clear medical opinion. Code E of PACE sets out further requirements in relation to interviews under caution, including the need to be audio recorded. And there are specific provisions requiring retention of a sealed copy of the master recording, outlining the requirement to take breaks, and setting out specific requirements at the conclusion of an interview. For example, a notice explaining how the audio recording will be used, notifying the arrangements for access, and confirming that a copy of the recording will be supplied to the defendant if charged. I've already suggested that unprofessional conduct by an investigator in interview could lead to the exclusion of evidence. The key provisions are found in Section 76 of PACE, covering confessions said to have been obtained through oppression, and Section 78 of PACE in relation to evidence which has been obtained unfairly. Cases under Section 76 tend to be rare. For example, a 13-hour interview of a suspect in the murder of Lynette White in Cardiff was ruled inadmissible on the basis that the suspect had been shouted at throughout to the point where he falsely confessed. Cases under Section 78 of PACE are much more common and have seen interviews excluded because of significant and substantial breaches of Code C. For example, a confession obtained from a suspect after he and his solicitor were falsely told that his fingerprints had been found at the scene of a burglary. In a similar way to PACE, CPIA outlines some basic principles of fairness that the police must follow during the course of an investigation. Non-police investigators are also required to have regards to CPIA and its associated codes of practice. The fundamental principle is that investigators must pursue all reasonable lines of inquiry, whether these point towards or away from a suspect. An investigation must therefore be a search for the truth rather than a determined effort to prove that a suspect is guilty. It is an approach that many professional investigators can struggle with, wanting to take the side of the victim, especially when confronted with a very different role of defence lawyer, which is solely focused on the rights of their client alone. Coming back to my earlier point about preferring to defend the outcomes of unfair investigations, a process which has fairly examined all relevant evidence and then presents an overwhelmingly strong case must always be the best approach. One important role outlined within CPIA is that of the disclosure officer, whose role is to manage the evidence obtained during the investigation. That will include compiling schedules of evidence, including identifying the material which is required to support the prosecution case, known as used material, and material which will not be relied upon, known as unused material, as well as considering whether any unused material may be of such a sensitive nature, for example, revealing confidential investigation techniques or personal details that could put someone in danger, referring back to the point made earlier by Matt. Material relied upon by the prosecution evidence will normally be disclosed to the accused with the service of the summons once it's been issued by the court. Unused material must be disclosed to the accused if it might reasonably be considered as undermining the prosecution case or assisting the case for the accused, and this is known as initial disclosure, again ideally served at an early stage. But it's important to note that the prosecution is under an ongoing duty of disclosure and must keep under review whether or not material may undermine the prosecution or assist the accused and disclose it if it does. Where sensitive material is identified, the prosecution cannot unilaterally withhold it. Where that material would otherwise be disclosed to the defence, it must be drawn to the attention of the court, that will rule on the steps that are required to ensure the defendant can still have a fair trial. And once again, failures in relation to disclosure are an area which can ultimately lead to the collapse of a prosecution case. The CPIA also sets out an obligation upon the defence to serve a defence case statement in Crown Court cases, giving details of the factual defence and any points of law. The service of a defence case statement is, however, voluntary in the Magistrates' Court, but may be used by legal teams seeking to obtain unused material. And the defence have a right to make a formal application to the court where they believe potentially helpful unused material is being withheld, but it is a prior requirement that the defence case statement must have been served, whether the case is in the Crown Court or the Magistrates' Court. The service of the defence case statement triggers an obligation on the part of the prosecution to review the unused material that it holds and to reconsider whether that material might assist the defendant or undermine the prosecution case in light of the factual defence and the issues outlined. During the course of the investigation, investigators carry the responsibility for conducting inquiries, including the decision to commence an investigation and its scope. However, it is appropriate and in many cases sensible for prosecutors to advise investigators, for example, on the aspects of the investigation outlined in the slide, including possible lines of inquiry, evidential requirements, procedure and compliance issues, disclosures, strategy, and ultimately assistance in relation to the charges that can be brought. My final points before I hand back to Matt is in relation to the importance of the Criminal Procedure Rules 2020 and the practice directions. The CPR set out the detailed procedures that must be followed in all types of criminal proceedings, covering issues such as case management, preliminary proceedings, arrangements for custody and bail, disclosure, evidence, arrangements for trial, sentencing, confiscation and related proceedings, appeal, and perhaps most importantly for any cost-conscious lawyer, the issue of costs. In most cases, the procedure rules are supplemented by more detailed practice directions, which give further practical guidance. Both the CPR and the practice directions can be found on the Ministry of Justice pages on the gov.uk website. I'm now going to hand back to Matt, who will cover a number of points relating to the decision to prosecute.
Thanks, Tim. Okay, so the investigation has been completed and you've decided in line with your enforcement policy that the matter warrants a prosecution. So you then need to be thinking about who is it that is empowered to authorise the instigation of that prosecution. And again, you're going to be looking back to your constitution and your scheme of officer delegation to identify who it is that effectively signs off, so to speak, on the commencement of that prosecution. Usually that would be a senior manager in a specific service area, assistant director or head of service. And quite often your constitution will provide that the decision is subject to the agreement of or is in consultation with your head of legal, albeit that the head of legal may him or herself subdelegate that decision down to his solicitors or lawyers. Once again, you need to be able to demonstrate that prosecution has been correctly authorised in accordance with your constitutional arrangements. If it isn't, then you may well find yourself on the wrong end of a decision as to the lawfulness of that prosecution having commenced. And the person authorising that prosecution needs to be satisfied that prosecution can go ahead on the basis that the full code test as prescribed in the Code for Crown Prosecutors has been met. The Code for Crown Prosecutors, so that is issued by the Director of Public Prosecutions as the head of the Crown Prosecution Service, and it provides guidance to prosecutors on general principles that must be applied when making decisions about the institution of a prosecution. It is binding on the CPS prosecutors and non-CPS prosecutors, such as such as local authorities, will apply with it either by convention. Other regulatory bodies are required to as a matter of law. The code sets down a number of general principles that apply to prosecutors. They're up on the slides there. I'm conscious of time, so I'm not going to go through all of those. You will get the slide deck in due course, but primarily it specifies that prosecutors must be independent, both from their investigators and from any political or other interference that may seek to unduly influence or affect their decisions. Prosecutors themselves, of course, are not the determiners of guilt or non-guilt. That isn't their role. That's the role of the courts. There are obligations for fairness and impartiality, and a requirement for prosecutors. They're also bound by the European Convention on Human Rights, the Human Rights Act itself, the various equalities legislation, any guidance issued by the Attorney General or the Director of Public Prosecutions, and of course are subject to criminal procedure rules and practice directions. So the full code test is a two-stage test, both of which must be satisfied. A prosecution can only commence when, firstly, the evidential stage is satisfied, that being that the prosecutor is satisfied that on an objective assessment of the evidence, it is sufficient to provide for a realistic prospect of conviction against each subject on each charge. And when making that determination, the prosecutor will take into account whatever the defence case may be and the impact that that defence case is likely to have on the prospect of conviction. The prosecutor will also be considering the reliability and the credibility of the evidence, the likelihood of it being held admissible or inadmissible, and the importance of any potentially inadmissible evidence in relation to the strength of the case against the suspect in the whole. Realistic prospective conviction, basically on an objective, impartial, reasonable jury or bench of magistrates or judge hearing the case alone, properly directed and acting in accordance with the law, is more likely than not to convict the defendant of the alleged charge. And it's important to say that that realistic prospective conviction test that the prosecutor must consider is not the same as and is a lower threshold than the test that will be subsequently applied in the court in determining whether or not the defendant is guilty, which of course is that the court must be sure of their guilt, as they used to be referred to as beyond reasonable doubt, which I'm sure most of you will be familiar with. If that first stage test is not made out, i.e. the prosecutor is not satisfied that the evidence is going to provide for a reasonable prospect of conviction, the matter ends there and the prosecution cannot be commenced. If the first stage test is met, then the prosecutor will need to go on and consider stage 2, which is the public interest test. So the evidence is made out to the prosecutor's satisfaction, but is he satisfied or she satisfied that the public interest requires the prosecution to go ahead? It won't automatically follow that just because the evidential stage has been met, that it will be in the public interest for the prosecution to go ahead. In determining that public interest test, the prosecutor needs to consider how serious the offence is, the level of culpability of the suspect, the circumstances of the harm caused to the victim, the age and maturity of the suspect at the time the offence was committed, the impact on the community of the offence, whether or not a prosecution is proportionate, and in cases of public interest immunity, whether or not there are information that would need to be disclosed that may harm sources of information or ongoing investigations. Not something that usually troubles local authority prosecutors, but it it is one of the considerations. And you will see on the slide that in making his decisions as to whether or not, or making those public interest decisions, there are additional criteria that will guide the prosecutor on considering and answering those questions A to G in the code. So I'm aware that time is pressing on, so I'm not going to run through those verbatim, but you'll be able to see them when you get the slide deck, and the code for Crown prosecutors is also available to download from the CPS website. So I think that is the end of our whistle-top high-level view. We've got a few minutes left, so I think now we'll have a look and see if we've got any questions come in, Tim.
We don't have any questions so far, but if there are any questions, then please do use the question tab to pose questions to us, and we'll be happy to answer those questions in the time left available to us. I understand that a question has come through. I'm going to read it out for Matt while I collect some thoughts on the subject, which is what has tended to be our advice where suspects wish a friend to attend with them.
So certainly no concerns with friends or relatives sort of attending the venue for moral support. I would rely on, I think, that the interview is going to be conducted in accordance with PACE, and PACE doesn't permit other than lawyers, appropriate adults if required, translators, to attend the interview. And you sort of like emphasise that compliance with PACE is to ensure the proper conduct of the interview if needs be, for the protection of the suspect, and rely on it being conducted in accordance with PACE, as I say, and that there is no provision within it to allow friends or relatives to sit in on the interview. And I would very, very much advise against it. Nothing good is likely to arise from an interview in which friends or relatives have been able to sit in.
And I would certainly echo the comments that Matt has made. I think one other sort of practical point is that quite often friends and relatives can end up being potential witnesses in cases, and therefore it will be totally inappropriate for them to have been present during the course of the interview. They also tend to be far more emotionally involved, and it tends to make the interview process very disruptive, and therefore on the basis that there's no legal entitlement for the friend or relative to be present during the course of the interview, my advice would almost always be against the attendance of a friend or relative. Again, if there are further questions that anyone wants to pose but wants time to compose them, then do feel free to send them through at a later date, and Matt and I would be very happy to answer them. I can see that there's a further comment in relation to the attendance of friends and relatives, which is that PACE doesn't explicitly exclude them. I think the point is that PACE sets out who you are legally entitled to be accompanied to an interview by. Obviously, if it's a voluntary interview, then almost all of the arrangements in relation to the interview do have to be agreed, but on the basis that there's no legal entitlement to have a friend or relative accompany you, then I would almost always advise against it. We then have a question in relation to, is there a police standard of translator or interpreter? And would a community member who was unrelated to the interviewee be reasonable? I think that's something that we would need to look at and provide advice on separately. I think you would need to be satisfied that the interpreter had sufficient qualifications and was going to be able to deal with it professionally, and also that there was they were completely independent from the process, because of course you are reliant upon the skills, qualification and experience of the interpreter for the quality of the interview to be conducted. Matt, do you have any thoughts on that question?
Hi, Tim. Yeah, certainly they need to be accredited. The police and the courts will have lists of certified and accredited interpreters. If a suspect has identified to you the need to arrange or the need for an interpreter, then as the regulatory body, such arrangements are down to you. I would be very hesitant and very cautious about using anybody that wasn't a certified and accredited police station and court interpreter, for reasons, as Tim has said, for ensuring accuracy and impartiality, and also potentially issues of compellability, as a witness. So if you do need to make arrangements for interpreters, I'd be having a look to see who in your area is an authorised police station and court interpreter.
So I can see another question, which was, we've had an advisor from a law firm trying to accompany a suspect to a PACE interview who wasn't qualified. You didn't let him in. The entitlement is to have a lawyer present during the course of the interview, and it is more a question, if they're employed by the law firm, it's more a question for the law firm to be satisfied in relation to the qualifications and the ability of the legal advisor to provide advice. Having said that, there are obviously accreditation schemes in relation to police station advice, but that's more in terms of assuring quality to the person who's being represented rather than the investigator. Having said that, you do need to be careful to make sure that they are genuinely employed by a law firm, and that there's no other reason for excluding them from the interview. But I would certainly want to look in a little bit more detail in relation to that scenario that's been posed. Again, Matt, any comments in relation to that?
Yeah, tricky. I mean, the PACE codes, they refer to solicitors. However, as you said, there are, there is a police station accreditation scheme which provides for appropriately qualified non-solicitors to attend police stations as accredited representatives. Trainee solicitors, they can attend, I think, subject to similar provisions. So yeah, I mean, it is a matter for the law firm really, and for the interviewee to kind of like to be satisfied that their interests are being best served. But yeah, potentially a bit tricky, but I would certainly say yes, good, check that person is actually employed by that firm, and that they're not kind of like saying that they are, or they're employed as the the tea boy or whatever. But yeah, primarily that is a matter for the firm and a matter for the interviewee.
I can see a further comment coming in from the person who asked the question, saying they weren't accredited either. I think by way of example, I could point to plenty of very, very highly regarded law firms in the City of London who advise clients only in relation to business crime, regulatory proceedings, don't do any high street crime. And the accreditation process really is only in relation to those who are seeking funding from the Legal Services Commission, so legally aided advice. And therefore, there will be plenty of people who are exceptionally well regarded, exceptionally well qualified to provide advice in relation to investigations who won't technically be accredited. And therefore, I think it is something that would have to be addressed on a case-by-case basis. But there are certainly cases which would support the exclusion of people who are inappropriate to carry out the role of legal advisor because there's some genuine reason to be concerned that they will interfere with the criminal justice process. So I think something that would have to be explored on a case-by-case basis. And then another question, Matt, perhaps if you could consider this, are there specific rules on recording PACE interviews as we're having issues with our new recording system?
Well, yes, is the short answer to that. And then there are the requirements are set down in Code C and Code E, and there are provisions there for what to do if your recording media fails during the course, of an interview, which basically means you're going to be left having to do an old fashioned typed handwritten letter. Sorry, what am I talking about? Handwritten note, which obviously not easy and time consuming. But yeah, Code E is where you need to be for that, and try it as the point may be. And I apologise if I'm sounding flippant, but yeah, try and get your recording media fixed.
And I think the point to make in relation to that those provisions are in relation to the unexpected failure in relation to recording media, and it certainly wouldn't be advisable to jump straight to contemporaneous notes because there's a widespread problem that the recording devices are not working. It is now regarded as such a fundamental provision in relation to the fair conduct of interviews. But yes, without wanting to sound flippant, it is vitally important to ensure that there is a proper electronic means of recording the interview. Okay, at that point, I'm going to close the recording. Thank you, everybody, for your time. I hope that you found the presentation informative. Thank you very much for the questions that have been posed. We hope that we've been able to answer all of them. But if you would like to post through further questions that we could have addressed at the end, then Matt and I would be very happy to consider them. So thank you very much once again, and we hope that you'll be able to join us again in a few weeks' time in relation to part 2 of this presentation.